It's 2021 and we are hopefully coming out of COVID lockdown. Welcome to the latest Skadi Podcast. In episode 11 of the Skadi Podcast, Nic talks with Tim Harris, Senior Associate at Cohen Gresser. Continuing the investigation theme that Skadi has covered in a number of previous episodes, Nic and Tim discuss why an external party might be brought into an investigation and some of the common flaws that might occur in an internal investigation that could strengthen the defence's case. They look at the implications of the senior managers regime and also discuss the recent high-profile money laundering case at NatWest.
Hi everyone, welcome to the next episode of the Skadi Podcast. We are continuing the investigations theme and taking this considerably further and looking at it from another angle. We're very pleased to be able to welcome Tim Harris from Cohen Gresser. Tim is a senior associate in the London office. And his practice focuses on white-collar criminal defence, including internal and regulatory investigations, regulatory enforcement, and financial crime compliance. He also worked on the defence team for Kwekwa Deboli in the UBS trial. And really for us, and our customers, our listeners that listen to the Skadi podcast, it's really great to be able to get someone in that has these insights that can really also help, strengthen the process around internal investigations, because everybody wants, a really robust and good and fair process. So it's a really warm welcome, Tim, to the podcast. Thank you for joining us.
Well, thanks for having me, Nic. It's good to be here. And I echo those sentiments as well around ensuring the fairness of an internal investigation. I think that's in everyone's interests, both the investigating company, the regulator, and or the enforcement authority, and of course the individual or individuals subject to the investigation, and then any follow-up regulatory or enforcement action that may be taken.
Yeah, well, we have listeners that because we cross a number of different practice areas, and we do have listeners that aren't in investigation. So I think just for them, Tim, can I ask you, from your perspective, why do banks tend to instruct external parties? What leads them to do that, such as lawyers, forensic accountants, investigation specialists, subject matter experts like Skadi? Why do they need to do that?
Well, I think it's important to initially to say that disputes with customers and counterparties and issues arise relatively frequently in the banking world, and certain banks, as we know as is publicly disclosed, have more disputes than others, and particularly where they have a UK retail focus. I think it's also important to recognise that banks and financial institutions generally don't instruct externally, whether that's law firms, forensic or experts such as Skadi, as a matter of course. It's not business as usual if they're doing that. Banks and firms themselves have very significant legal and compliance functions. They also often have ex-police who carry out internal investigations for the firm, so they're pretty able to handle very significant financial crime issues as and when they arise. They've got quite a lot of bandwidth to carry all that. I think the instruction of external investigators then is unusual and is not a business as usual decision. It sucks up a lot of bandwidth, both for legal compliance and also for the business as well, who'll be providing information to the investigators. And it creates a lot of tension within an organisation. So it's a big decision to bring in an external party. And as you say, why do they do it? I mean, I think they do it because they generally only do it when they suspect that serious regulatory and criminal conduct has occurred. There are investigations behind all of that. There's potentially a disclosure to the market that be necessary, disclosure to the FCA and also to other authorities such as the NCA for money laundering or the SFO for bribery and HMRC for tax evasion. So they're instructing externally to understand the issues and understand who's involved, and as I say, with a view potentially to disclosure and ultimately, I guess, if there is systems and controls failure, to put those systems and controls failure right. I think as well, with instructing external lawyers, the advantage that they're getting over, for instance, instructing external accountants is potential protection for the investigation through privilege or by privilege, so they can cloak the findings and the work product from that investigation from any subsequent disclosure to the authorities. And they're not doing that in order to push things under the carpet. They're doing that really in the knowledge that they can go as deep as they possibly can to investigate it, knowing that if they do find something, very bad, that they might not need to disclose it. I mean, if they thought that they might have to disclose everything, then they might not go quite as deep as they might ordinarily want to. So
I think that's a very interesting point.
That's a very interesting point.
Yeah. I mean, we did have Sarah Wallace talking about privilege as well on her podcast. That is it is interesting to us. You touched on one thing, which is and this is something that we wanted to talk about, which is when an investigation identifies criminal wrongdoing, what's the next critical steps for the investigation team? And you'd hope that doesn't happen, but it happens from time to time. So what should the investigation team do?
Well, I think what the next steps that they will decide upon really depends on the source of the allegations. That will affect the course and how it's carried out and what the output will be. I think the way in which I tend to see it is, broadly speaking, there are three sort of generic types of investigation that are carried out in response to allegations. There's the first type of investigation that might be carried out following a confidential whistleblower, or where the bank's own intelligence team has identified some issues, or in fact a confession from within the bank, as happened with on one of the cases I acted on Kweku Adeboli. And they're trying to identify privately there the extent of the issues, and to a certain extent, because it's confidential, the bank can set its own agenda as to how it's investigating those issues, assuming they don't leak publicly, and what it chooses then to do with the findings from the investigation, whether it's to self-report or as it might be required to do, or make a disclosure, for instance, under the money laundering regs. So that's one type. I think probably more problematic for the bank is where the issues have come to light and have been played out publicly, potentially because the issues have been brought to the attention of the FCA by another regulator, as happened in LIBOR, or where media have reported on the issue, where there's been a whistleblower, for instance, who's gone to the media, and that happened relatively recently on Unioil, which is an oil and gas services company who provided services to a huge number of oil and gas majors, and they all were required in the public spotlight to conduct an investigation. And in those sorts of circumstances where it's been carried out in the public eye, they obviously have a significant reputational implication, and the market is expecting updates, and it may be also expected to disclose its findings as a matter of course to the enforcement authorities or to the market. I think the third type that is carried out is where the company is rather sort of incidental to the allegations of wrongdoing, and it all might be happening with the bank or the financial institution as a bystander. So I'm thinking particularly with insider dealing cases where in circumstances where the intelligence force from the bank hasn't tipped off the FCA, but where the FCA or the NCA themselves have been covertly investigating a matter, and have come to a conclusion that someone within an institution has dealt or has been leaking inside information, they might raid the individual's house and raid the specific person's desk, for instance, in the bank, and that is really rather taken out of the hands of the institution, although the institution then may investigate the wrongdoing and seek to identify who might have been involved with him or her, and then there may also then be disclosure obligations for them to provide documents and information to support the insider dealing investigation. So I think those are the sort of the three main categories, and then I suppose that those first two are really the most interesting ones for us, I think, because they really involve much more of a role for the investigator, really seeking to understand, the number, what has gone on. And I think that, what an investigation is really trying to do is a number of things, but essentially, I suppose you can look at it almost as like a police investigation, that they're seeking to understand the extent of the wrongdoing, who is involved, who are the witnesses and the suspects, what are the implications? So has there been financial misstatements? Is there customer detriment? Is there loss to the bank, of course? And does this mean that there might be some solvency issues? Or whether there's a false market in the shares? And then they're thinking, quite quickly, whether they need to be disclosing those issues to the FCA as they might be obligated to, and whether they need to tell the market. And I mean, they're going to be expected to tell the market very quickly. It's not uncommon for them to if an issue is discovered on day one, then by the morning of day two, they need to be making a disclosure to the market if they're a listed business. And they also want to be understanding.
That's very interesting, Tim. That that response time has to be that quick for listed firms, or do they have a bit of leeway around that?
I think typically, that under the disclosure rules, given that a false market will have occurred in the shares, and the market won't know about, for instance, if the books are irregular, the company will disclose that to the listing authority, to the FCA, and the FCA will be pushing for an announcement to be made at about the time that the market begins to open. Alternatively, the shares also can be stopped from trading as well. If there is, if it's too early to tell, what is the extent of the wrongdoing, and people don't know what then the shares should be worth. So the shares can actually be suspended pending the investigation. Right.
Crikey! Well, we haven't seen one of those for a while. Thank goodness. I'm very interested in in your sort of background, your input into this is really what role the internal investigation team might have as things do get quite hot, and things move to a kind of prosecution footing. Is the internal investigation team still involved? What happens?
Well, I think the approach of the corporate and the investigation team will depend on the role of the prosecution, assuming the matter has been self-reported to the authorities, under the first two examples that I gave. Some firms will be victims of the activities of an individual and may have an interest in seeing the individual as successfully prosecuted. I think in that sort of situation, they're going to throw quite a lot of resource in assisting the CPS or the SFO, whoever it is, in carrying out the prosecution. Other firms where they have decided to cooperate very early on and have self-reported the matter may have entered into a deferred prosecution agreement or sought a reduced regulatory fine. I think that was the position that's been the position with, for instance, Tesco and Serco more recently, and a number of other private companies private companies that have done DPAs, but then Airbus and Rolls-Royce as well. But then also the banks involved in the benchmark investigations. Although those weren't DPAs, they were this sort of civil settlements. But there's a strong emphasis on cooperating with the inquiry, and that means doing an awful lot to disclose documents, identify individuals who may be involved in the wrongdoing, and identifying witnesses who might assist with the prosecution. I think that involves, that role involves a huge amount of disclosure of electronic and audio data, and providing company documents and official minutes, compliance documents, that sort of thing that will go to assist the prosecution. I think there's also another situation where that, as we saw in the Barclays Qatar case, where the company itself might be under investigation itself as a suspect, as opposed to a sort of a cooperating witness. Particularly, and in that situation, that the company will be incriminated through potentially through the activities of its senior management. And on Barclays' case, you saw both Barclays and senior individuals being charged. And so in those circumstances, the interests of the company and the individuals are quite closely aligned in a way that they might not be with the first example that I provided, where they're cooperating and providing a lot of documentation to the authorities to assist with their prosecution.
Right. But I can see there it would be in the interest of the company to perhaps find out still the extent of the damage internally as well, perhaps. I'm not sure whether they would be prevented from investigating. Can that happen?
Yeah, it can be to a certain extent. So once you've self-reported the conduct, then the authorities will take quite a close. They'll carry out their own independent investigation, and they'll keep quite a close eye on what the company can do, and they'll often prescribe what the company can do to investigate. So, for instance, the company might be allowed to carry out a documents review, and it might be asked to share that documents review with the prosecuting authority, but it might be asked not to carry out interviews with the individuals for fear of tainting their evidence. And so the prosecuting authority will itself want to speak to the individuals. You see that actually with a number of the deferred prosecution agreements that we've seen relatively recently, and I think we'll come on to talk about that. But those are an issue for individuals. Let
me ask you about that, Tim. I mean, you mentioning individuals. How do individuals fit into the investigation process? And we're sort of moving, more towards your area now, I think, to help us.
Yeah. Well, I've got quite a lot of experience both acting for companies in the investigation, but also acting for individuals in internal investigations. And clearly, companies can only commit wrongdoing through the acts of its individuals. So the individuals who are implicated in the wrong are going to be closely scrutinised by the investigators. They're likely to be interviewed, and they may also very well be subject to disciplinary proceedings. I think it's important for individuals to appreciate their role in the allegations, and ultimately, as we sort of set out at the outset of this, to understand the bigger picture and how they might fit into it all. And I think that can affect their strategy and how they decide to engage with the investigation, because for the most part the investigation has been conducted on the company's terms, and they'll have certain objections in mind, and clearly the conduct of some of those individuals may have implicated the company, and so a key output or an outcome for the company is to minimise the reputation enforcement action that may result from this misconduct that it's identified, and acting in the best interest of its shareholders is to mitigate the allegations, the fines, and the penalties. So it may, for instance, suit the company to try to pin the misconduct on an individual or a small number of junior rogue employees, call it what you want, who have acted outside the company's controls, and which the company therefore was unable to prevent. In that scenario, if you've got a small group who are alleged to have committed the wrongdoing, as opposed to it being endemic, then that's going to be a better look for the company, and therefore the company almost has sort of an interest in dressing this up in a way that best assists it into minimising its fines. So what we've seen with some of these DPAs is that the company has carried out an investigation. It has self-reported the matter. It has then cooperated closely with the authorities, and it has identified individuals that are implicated in the wrongdoing. And effectively, I suppose you could say that it's throwing those people under the bus. I mean, and it does that for a number of reasons. I mean, in doing so, it's hoping to obtain cooperation credit by identifying individuals. It's going to assist in any later sentencing if it can show that this misconduct has been carried out by a few rogues and not endemic. And also, it's important that the upper management and legal and compliance department weren't aware of the relevant issues, because of course if they were and that was ignored, then that exponentially increases the seriousness of the offending for the obvious reasons that their systems and controls weren't effective. So we've seen individuals, and very recently actually it's quite on topic, because this week we've seen individuals on trial for alleged misconduct in contracts between Serco and the Ministry of Justice. They've been acquitted following a trial at the Crown Court very early on, following disclosure issues because of in relation to documents that have been disclosed to the SFO by Serco at the time it entered into a deferred prosecution agreement. So on the one hand, the company, Tesco, Serco, whoever it may be, has got an interest in wrapping things up relatively quickly, although it took 8 years to reach an outcome with a fine. And implicating individuals and senior individuals at that who have carried out this misconduct. But then actually when it's got in front of the courts, the allegations of wrongdoing against the individuals have fallen apart and have just not stood up to the rigorous scrutiny imposed by the court.
Well, Tim, fair's fair and all that. So I'm going to ask you this question, and maybe a vested question, given I'm an ex-front office professional. But should I ever find myself on the receiving end of an investigation, which is not where I normally find myself these days, what tips would you give to me about how I should conduct myself in an internal investigation, or how should one? What are your tips for those people that do find themselves on the receiving end of an internal investigation?
Well, I think it's important to get advice. I would say that being a lawyer, but I think as early as you can, get advice or seek help, and often the firm will provide you with a lawyer, particularly when it's investigating serious and regulatory misconduct. It's not required to do that, but I think it's always good. I think it always means it's a fairer process if the individual is represented. But I mean, I think it's really critical then, in consultation with your legal advisor, is to really understand where you are in the process. Are you a witness? And I often act for people who are involved in sprawling investigations, and they may have been involved in email chains with people who have subsequently become implicated. And quite early on, you can see that person is not in any regulatory or criminal trouble, but is being interviewed in order to get his or her view on what he saw or the conduct of others around. However, if though it's becoming more more obvious that person is actually a suspect, i.e. they're being, the allegation is that, they have carried out the misconduct that this investigation is looking into. Again, there's a spectrum of wrongdoing, which we've come across. But I think the approach to the individual to that investigation will depend on where they are on the spectrum. If it's becoming pretty obvious that this is being treated exceptionally seriously, you've got a lawyer even which the firm is paying for, and they're asking you, questions, and there's going to be a lot of people in the room, etc. Then, a decision has to be made as to whether you're actually going to cooperate with that investigation. It doesn't happen very often, but it might be that the best thing is for you not to answer questions in the internal investigation. Clearly, that's going to have implications for your job. Unless you've got a reasonable excuse not for answering questions, it's likely that that's going to be a disciplinary matter and will probably lead to your dismissal from the company. But that might be the better thing to do, rather than give an account in interview, which might then subsequently be used against you in later regulatory or criminal proceedings. So I think they need careful. The allegations need careful assessment, and I think it's I think it's important to take a view quite early on, because I think unlike in a police interview, you're not entitled to the statutory protections. You're not entitled to a lawyer, for instance. But I think most reasonable internal investigations and investigators now will appreciate that while an individual isn't necessarily entitled to being represented, there's definitely all sorts of upsides for the individual to being represented. I think that that you tend to get better quality of information from a well-prepared individual who's sought advice, particularly because these matters go back over a number of years. And I think with having a lawyer there, well, it does add to sort of a level of administration and potential challenge. I think that person can advocate on your behalf and can ensure that you have your rights are enforced. So, for instance, I think that it's important that some sort of pre-interview disclosure is provided, which gives you a summary of what the allegations are. You might also ask to cite some documents which your lawyer might be able to review and can then talk to you about and prepare you for the interview. I think you can also ask to see the transcript. You might not be able to see it, but you might, if a note's being kept, you can also ask to edit it. And I think it's important to recognise that the investigators want to get the best possible evidence from you. It's not in their interests to obtain, badly remembered or worse, misleading information from them that might actually make the position worse for the company. So I think it's important that although these things are very sort of time sensitive, and the issues that are being dealt with are incredibly confidential, I think it is well worth ensuring that, particularly for the individuals who may have incriminated the company, that you're really getting the best possible information from them.
Well, can I sort of I think fair is fair again. I mean, we've asked sort of what advice you'd give to people who are on the receiving end of the investigation, and most of Skadi's listeners, I'd say most of them, there'll be some that will be on the other side of the fence, but most of them probably will be people that are actually conducting the investigation interviews. So can I ask you this? Tim, what are the kind of common flaws and common mistakes that you commonly see arising in internal investigations that can really strengthen the defence's case? What do you see there?
Well, I mean, I suppose it's what is the defence's case. I mean, if you're talking about it being a regulatory or criminal proceedings, I mean, these can often happen 2 years or way more. I mean, in Serco, I think the individuals have been under investigation for 8 years. So the the internal investigation on that matter may well have happened 8 years ago, might have happened 6 years ago, but it's happened an awful long time before the allegations are actually coming to be challenged and the product from the internal investigation is being looked at in a court process. So it takes quite a time lag in which the flaws of any prosecution can play out. But I mean, I think the DPA is a good example too, where these sort of DPA settlements that corporates and the SFO are agreeing is then leading to disclosure issues which can ultimately be exploited, as you say, and strengthen the defence's case, because it's almost meaning that sort of miscarriages of justice are happening because sort of certain documents aren't being disclosed. I think the main issues is that for instance, that if an individual isn't represented in an internal investigation, that will often mean that while the interview might be disclosed to the prosecutor, and it might form the basis of an internal investigation report and allegations made against that individual. If that individual wasn't represented in an internal investigation, it would tend to mean, not definitely, but would tend to mean that the interview note would be inadmissible for the purposes of criminal proceedings. So, if the prosecution's main evidence is founded on that internal investigation interview, well, obviously that's not going to be very helpful to them, and that's why, as I said, that the SFO and the FCA tend to like to conduct their own independent investigations and speak to the individuals themselves, so that they can, so they can get an admissible transcript of an interview. I mean, I think one of the main, and this isn't necessarily an internal investigation point, but it's a sort of a learning point from enforcement authorities, is not to rely heavily on the product of the internal investigation. The SFO got in trouble, probably more than 5 years ago, against in a high-profile oil and gas case where it had outsourced the investigation of the bribery in a company which took place in Bahrain. The internal investigation firm, a US firm that carried out that internal investigation, became prosecution witnesses, but they decided, for reasons of conflict, that they couldn't come to the English court to give evidence, and the court case collapsed really after they couldn't come to give evidence, and the SFO was very badly criticised about that. So the SFO now, as I say, carry out their own internal investigation, but often what we find is that the theory that of fraud or bribery, whatever it is, that is expounded initially by the internal investigation team quite closely mirrors the final theory of fraud that is prosecuted. And coming back to my Serco case, that can often mean that the case isn't necessarily a strong one, where the company has sought to implicate more junior employees, albeit directors of a subsidiary, but hasn't implicated the senior people at the board level. And so that's really one of that's really been the sort of the area at the moment that individuals are sort of challenging the internal investigation report, particularly where it leads to these deferred prosecution agreements.
Well, you've handed on a couple of interesting things there. I might just ask you about, so time, you've highlighted, obviously, the length of time between an investigation happening and then the matter, reaching the courts, etc. Let me ask you just quickly about record keeping, because I as an ex front office person, remember, under FCA regs, we've got to hold on to data for 6 years, etc., and maybe longer. In an internal investigation, are there any prescribed time limits that investigation teams have to hold on to, not just the report, but all of the data that they've gathered, etc., around an investigation? What do you have any line of sight over that?
Well, I mean, under the GDPR, you're only supposed to hold on to personal information for as long as is necessary. I mean, law firms are, terrible at just holding on to documents for time immemorial, and it's, they're archived in a warehouse somewhere. I mean, what tends to happen is that the internal investigation product is given, if it's a report, it's, it might be produced where the company is cooperating, but then there'll be, production after production of documents that may be relevant to the investigation, and audio recordings as well, of course, in financial institutions. And then it is reviewed by the prosecuting authority, that can take a very long time. The documentation should be what it is, but it might mean that the people who've carried out the investigation come to give a witness statement, and clearly that lag in time between the internal investigation and the allegations that were central to the investigation, which are now central to the prosecution. Yeah, clearly, I think it's a source of challenge, strong challenge from an individual, to argue that this isn't a fair process if it's taken so long for the prosecution to come on. I mean, it may potentially, in certain cases where there's such a significant delay, and then there's issues that arise from that around disclosure and memory recollections. It might be an abusive process to have a criminal trial. That's a very high hurdle to meet. But clearly, it's the time limit. A long time delay is only going to be exploited by an individual. I say exploited, but it's going to, they've been living with this case for such a long period of time that it's not fair. But it is one of the things that you can use to your advantage. For individuals under investigate, one of the things, it's so difficult to know what to do with your time. For these Serco guys who've been under investigation, living under a cloud for 8 years. I mean, it's appalling to live your life under that sort of cloud, waiting for a charge. I think the charges were roughly about 18 months, 2 years ago. So they've been investigated for 6 years, then charged, and then within sort of 2 years, then they come on for a trial, and then it doesn't even make the halfway stage of a trial. The judge throws it out so early on. I mean, that's appalling, isn't it?
Yeah, no, it is very tough. I mean, well, we've talked about individuals, but we do a lot of work in the financial markets. I want to ask you about what the implications are, with the senior managers regime on the managers of individuals that are being investigated. Yeah,
it's still a bit of an unknown, really. I mean, the senior managers regime is held up by the FCA as a success story. It's seen as embedding risk controls through an organisation by way of personal liability for the senior individuals, and thereby they say it creates a sort of a virtuous cycle where effectively senior managers in their haste, in order to protect themselves from personal liability, have a strong responsibility to have risk controls, holistic risk controls that are embedded throughout the business, and that therefore reduces the chance of non-compliance by the firm. And so far, that isn't playing out into regulatory enforcement action against senior managers or against firms. But I don't know, the cynic in me thinks that there is a risk that by imposing personal liability on the senior managers, you may create a perverse incentivization for the senior managers and for the firms who are going to bear the brunt of the fine, to argue that, a bit like what I've been talking about earlier, is that the failure of control is caused by the less senior individuals, and that the senior managers weren't responsible because they couldn't have reasonably prevented the failure of the system and control that is under scrutiny. So I don't know. It's yet to play out. I think an interesting case is the NatWest case that we might come on to speak about later, and whether that will have any implications for the senior managers there.
Well, let's talk about that, Tim. Let's talk about that case, and let me get your views on that one, because we've been talking for quite a while. So let's talk about that one.
Well, it's huge. I mean, it's a really big deal for the FCA to charge a UK retail bank with an offence under or offences under the money laundering regulations. I mean, Mark Stewart has regularly talked about using the criminal provisions in the regulations in order to give bite to the regime, and has criticised banks for not taking money laundering seriously. I think this prosecution crystallises the risk for the firms. I mean, previously Stewart has said that the money laundering regs offences would only be used for egregiously poor systems and controls and what looks like actual money laundering. So I think what they're actually alleging is that NatWest, through its failure to police its systems and controls around enhanced due diligence and ongoing monitoring, has effectively facilitated money laundering. And that's a big deal. No individuals have been charged with the bank, so no individuals appear to have been implicated in the money laundering scheme itself. They also haven't committed a money laundering offence, which they might do if they knew or suspect that another person was money laundering, or themselves were, they could money launder themselves. So there's no failure to disclose issue here, but it will be interesting coming back to the senior managers regime, and given the timing of the offending or the alleged offending and when the senior managers regime came into force, whether any senior managers at NatWest are subsequently held to be culpable for failing to prevent the breach of the systems and controls, whether there was anything they could reasonably have done to prevent the systems and controls failings. At the moment, we don't know anything about that, but it's significant. I mean, it will also be interesting to see how the fine plays out. We've seen previous cases under the money laundering regs being dealt with through the civil process and through the application of the FCA's enforcement guide, and the way that fines are calculated there is different to the way in which they'd be calculated in the criminal court. So they're taken as a sort of a percentage of revenue for that particular bit of the business under the FCA's regime, but under the criminal court it will be there'll be a starting point of the amounts that will have been laundered, and then it will go up based on a multiple of a number of things, a number of aggravating features, including the seriousness of the control deficiencies. So the bank's controls, will really be under the spotlight, and really interesting to see how that plays out and what the implications are for other people working in the sector.
Well, Tim, that's been absolutely terrific. Thank you so much for sharing this time with us. I found that a really terrific episode, really enjoyable, and a wealth of information. And I feel that there's so much that we could have talked about and really gone into in more detail in what we've spoken about. So thank you very, very much for joining us. And that's been really illuminating. Thank you.
No worries. Thank you very much for having me, Nick.
Thank you for listening to episode 11 of the Skadi Podcast. Stick with us on this journey as we, like many of you, are trying to navigate our way out of the pandemic.